Okay, we'd like to call the meeting to order. If we could please rise and for a moment of silence and the pledge of allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We have the roll call, please.
Jamie Girardi. Michael Cox.
Here.
Peter Hansel. Roy Lozada.
Thanks.
Chris Williams. Chairman Charles Gray.
Here. Okay, proof of publication.
The items were published in the Tampa Bay Times on July 26, 2019, and on September 27, 2019.
Okay. Do we have any minutes?
Yes, there are minutes, I believe.
Okay.
Is
So,
what about PC4?
I have a motion to approve the minutes.
Motion to approve the minutes from the meeting on June 20th.
Second.
A motion and a second. Further discussion of the minutes. All in favor?
Aye.
Opposed? Motion carries.
Okay.
Okay.
Okay. So we're gonna have to-
So for those of you who have come here today and you think you may want to get up and speak, we want everybody to stand and raise your right hand and be sworn, please. If you don't intend to speak, you don't need to stand up.
Do you swear or affirm the testimony you're about to give is the truth, so help you God?
Okay, I'd like to welcome everybody today. We're the Planning Commission. We're appointed by the Board of County Commissioners. We meet twice a month. We serve as a local planning agency and we hold public hearings and transmit to the Board of County Commissioners recommendations on comprehensive plan amendments, land development code amendments, rezonings and conditional use requests. Planning Commission is the final decision-making body for special exceptions and certain appeals, variance requests, and alternative standard requests. However, the final decisions may be appealed to the Board of County Commissioners. Anyone that's in opposition in any comprehensive plan amendment, land development code amendment, rezoning, conditional use, or any item where the Planning Commission transmits a recommendation to the Board of County Commissioners, it's important for you to attend the appropriate Board of County Commissioner meeting. For those who are not familiar with our format, I'll go over it as quickly as I can. We have continuances, and it's been our custom to approve requests for continuances from the staff or from the applicant, unless there are extenuating circumstances. We have a consent agenda, and that's on that agenda are items that and we have not received any objections from staff or from the public. And we'll go through that consent agenda on an item-by-item basis. If there's something on consent that you'd like to have discussed today, when I read it off, please raise your hand and we'll pull it for discussion. Otherwise, it remains on consent and we'll vote on it all at one time and approve it and move forward. Then we have the regular items. Anything that comes off consent will go into the regular items, and those items will be talked about today on a per item basis. Applicants will have 3 minutes to make their presentation, and residents with concerns or objections will have 3 minutes. If there has been a request at least 24 hours in writing prior to this meeting, we may grant extra time. If you have a phone and it's not on silent, this is a good time to put it on silent so it won't interrupt anyone. And before we start the regular meeting, we open the meeting for public comment on any items not appearing on on today's agenda. Is there anybody here for an item that's not on the agenda? Okay. So you know what? All right.
Good afternoon, Planning Commission members. Denise Hernandez, Planning and Development. I'm not sure if Mr. Goldstein would like to discuss this, but there does not appear to be a quorum for the item that includes an increase in density, which is PC 10.
So, Denise,
So-
I guess first question is Mr. Williams, did he say he was going to attend?
Mr. Williams said he was going to attend. I have an email into Mr. Williams explaining to him that we need him for a quorum for that item.
Well, my concern isn't just that item, because I re-looked at the code, and reading the code, I think even PC 3, because it's a school, and PC 4 are technically items that he's supposed to be voting on, the way I read the code. 'Cause the code says, a second, I'm pulling it up here. It says, all matters relating to rezonings or land use changes that would allow one or more residential units. That's one. And it says regardless of what the existing zoning or land use allows. And then there's another one that says all matters related directly or to a proposed or existing school site. Now, one might argue that's just a public school site, but it doesn't distinguish between. So my concern isn't just about PC 10, it's also for PC 3 and 4. So that's why I asked if Mr. Williams is going to show up, because if he is, we can just defer those 3 until he's going to show up. Otherwise, the planning commission can't take, I don't think they can take action on those 3.
So again, Mr. Williams did state that he was attending when we contact him to determine what the attendance was going to be, but is not here at this time. I don't have an email from him stating that he's not attending. I just sent him an email asking whether he was attending, that we needed him for a quorum. So I'm awaiting the response.
Okay, well, this time, there's not much we can do about those 3. So I guess we're just going to have to put them on hold to see whether he shows up.
Okay.
Okay. All right. Okay, so then we'll just start with PC 1.
Okay. PC 1 is PDD 20-7440. It's a special exception in the name of Gianna Marie Ciervo Fragoso. It's for a kennel for dog training, boarding, and breeding in an agricultural residential district. This comes to you with a recommendation of approval with conditions as contained in your packet.
All right, is the applicant present?
Yeah.
Anyone here to object? Okay, we'll keep it on consent. Go ahead.
Item PC2 is PDD 20-7441. Special exception in the name of Kelsey and Jeremy Whitmer. It's for a bed and breakfast tourist home in an AR agricultural residential district. And this comes to you with a recommendation of approval with conditions as contained in your agenda packet.
All right, is the applicant present? Anyone here to object? No objection seen.
Moving on to item PC5, that's PDD 20-7444 in the name of Seven Oaks MPUD, Master Plan Unit Development District. It's Specialty Malls of Tampa, Inc. It's for a substantial modification to the currently approved Master Plan Unit Development District and conditions of approval to allow an additional use, which is a brewery. And this comes to you with a recommendation of approval with conditions as contained in your packet.
All right, is the applicant present? Anyone here to object? No? Okay.
Item PC6 is PDD 20-CU01 in the name of VMR Development LLC, Chipotle Mexican Grill. It's for the sale of alcoholic beverages, beer and wine only, on premises consumption, in conjunction with the operation of a restaurant with outside seating and service of alcoholic beverages on a patio in a master plan unit development district. There is a correction on this one, which is finding of fact number 1, states that it's currently under construction. It's actually now fully constructed and open.
Okay.
Just want to make that correction.
All right, and is the applicant present?
Yes.
Anyone here to object? Okay, see no objections?
Following item PC7 is PDD 20-CU03 in the name of Pasco Ranch, Inc., Blaze Pizza, for the sale of alcoholic beverages, beer and wine only, on-premises consumption in conjunction with the operation of a restaurant with outside seating and service of alcoholic beverages on a patio in a master plan unit development district. This comes to you with a recommendation of approval with conditions as contained in your packet.
And is the applicant present? I would have heard somebody, but I didn't see him. Oh, okay. There you are. You're just so little over there. Okay, anyone here to object? So no objections.
Item PC8 is Trinity Hotel Group LLC, Hampton Inn Trinity. It's a conditional use for the sale of alcoholic beverages, beer and wine only, on premises consumption in conjunction with the operation of a hotel with outside seating and service on a pool deck in a master plan unit development district. This comes to you with a recommendation of approval with conditions as contained in your packet.
And the applicant's present? Yes, sir. Anyone here to object? No objections.
Following item PC9 is PDD 20CU04. It's conditional use, Trey LLC, Starkey Market, for the sale of alcoholic beverages, beer and wine only, on premises consumption in conjunction with the operation of a produce market and U-Pick with outside seating and service of alcoholic beverages in a master plan unit development district. This comes to you with a recommendation of approval with conditions.
All right, the applicant's present? Anyone here to object? Okay.
Following item is PC 11. This is a rezoning, PDD 207438, in the name of Lace Land Trust. It's for a change in zoning from a C1 and neighborhood commercial district, and RMH mobile home district to a C2 general commercial district. Comes to you with a recommendation of approval.
Okay, PC 11, is the applicant present? Anyone here to object? See no objections?
And that's the end of the consent agenda, minus those items that,
Mr. Chairman, I'll move for approval PC 1, 2, 5, 6, 7, 8, 9, and 11.
I'll
Okay.
second.
We have a motion to approve those items identified. And we have a second. Any further discussion? All in favor?
Aye.
Opposed? All right.
okay. And at this
Okay.
time, I have not heard back from
So for
Mr.
those of you
Williams.
who were here for any of those that we just voted on, you're welcome to stay or you can take off, whatever you'd like to do. And we wish you well. So we want to go to P12?
Should I go to P12 or should we?
Well, there's, unless Mr. Williams, I mean, we can always stop and vote on those items if Mr. Williams shows up, but there's nothing we can do on those other three until he shows
My
up.
phone is ringing. Can I answer it?
Pardon me?
My phone is ringing. Can I answer it?
Yeah,
It might
go
be
ahead.
him.
Who do we have here for PC3, PC4, and PC10?
For PC4 on each item representing amended right.
Okay, so we have two people, right? Okay. All right, well,
Was that Mr. Williams calling?
No, it wasn't.
Okay.
Sorry.
so we'll just
I was
have
being
to,
hopeful.
we're gonna go to 12 and then we'll see if he comes.
Go to 12? Okay.
Hopefully we'll get lucky.
I just said pointing out that if he does show up, you can always suspend the discussion of 12 and
Okay.
take up those three items if you
Gotcha.
so desire.
Yeah, probably a good idea. Like most of your ideas.
Okay, I'm just moving forward to PC 12, and then also, I would like to state that on this item, there's several requests for additional time. There is a request for 12 minutes of time from Matt Newton. There is a request for 10 minutes of time from Judy Geiger, and there is a request for 6 minutes of time from Robin Reinsmith on this item. All right, item PC 12 is PDD 20 CU01, which is actually, that's the agenda memo number is actually CU 1940. It's for a request for a private skeet shooting range in an AC agricultural district under the names of Arthur J. and Dory D. Vizzi. The parcel is located in north central Pasco County on the west side of Bellamy Brothers Boulevard, approximately half-mile east of Johnston Road. The skeet shooting range that's being proposed consists of a skeet field made up of shooting stations and 2 trap houses. There are no residential structures currently on the subject property. This is as a result of a Pasco County ordinance violation warning notice for site development without first obtaining a site development permit and conditional use. The surrounding area is characterized by rural residential development and agricultural pursuits. This is a site plan, which is a larger version in your agenda packet that shows the skeet shooting range. This is a visual representation of a photograph of the skeet shooting range. The skeet shooting range consists of a high house, I don't know that I can do this, okay, a high house and a low house and shooting stations around. There was a neighborhood meeting in accordance with the Land Development Code requires a neighborhood meeting. It was held on July 1st, 2019. There were several letters of objection that have been received from property owners adjacent to the north and south, 530 feet north of and 0.38 miles north of. The letters of objection are shown in the green. The subject property is the red piece of property. This is south of, north of, 0.38 miles, and, 530 feet and 0.38 miles over here. Surrounding zoning is AC Agricultural District. Future land use is AG and some AGR in the surrounding area. This is the aerial, the access to the properties from Bellamy Brothers Boulevard. And you have a staff recommendation of approval with conditions. I would like to go over the conditions because I believe that that's going to be, those are going to be discussed by the applicant as well. So these are in your agenda packet, but I'm going to go over them as quickly as I possibly can. The conditional use is for an outdoor private skeet shooting range, limited to the area shown on the site plan submitted with the application. Maximum number of persons engaged in skeet shooting activity at any given time shall be 4. That is actually consistent with the narrative that's provided in your packet in finding of fact number 3, explaining that the number of people that are typically on the property, I believe that this is actually 1 over what they're explaining. Days and hours of operation, Monday through Saturday, 9 a.m. to 4 p.m. with no skeet shooting activities on Sundays or holidays that are designated by county or state of Florida pursuant to section 110.117 Florida statutes. Third condition, there's actually a typo there. There should be an additional 3. I think it says 790.33. It's actually 790.333. Florida statutes, owners, applicants shall apply appropriate environmental management practices to minimize or eliminate environmental impacts associated with private skeet shooting range, using as guidance the best management practices for environmental stewardship of Florida shooting ranges as developed by the DEP. Such practices include but are not limited to control and containment of projectiles, prevention of the migration of projectiles and their constituents to ground and surface water, periodic removal and recycling of projectiles, and documentation of actions taken. Number 4 is obtain all county and state permits, not limited to SWIFMA DEP permits as applicable. Number 5 is as a response to finding of fact number 9, where we sent a request for comments to the Natural Resources Division. And Natural Resources Division stated that prior to the preliminary site plan, they should submit a wildlife survey to identify plant and animal species listed as threatened, endangered, or of special concern by the FFWCC or the US FWS. This is condition number 6. It's kind of long, but basically ensure that the outdoor skeet shooting range design and construction is in accordance with industry standard best practice for all matters of public safety, including containment of discharges within the private skeet shooting range. In the event other forms of firearms are used on site where the base of the trajectory is horizontal, the owner's applicant shall ensure compliance with industry standard best practices for all matters of public safety, including containment of bullets or other discharge projectiles within the property through the installation of berms, backstops, baffles, eyebrow above the berm, and or other standard best practice forms of containment. The owner's applicant shall ensure that neither litter nor projectiles associated with the activity shall be allowed to escape the confines of the subject property. The owner's applicant shall design and construct noise buffering, noise abatement features consisting of a wall or earthen vegetated berm of a minimum height of 20 feet as measured from the existing grade elevation to limit the noise impacts on adjacent properties to the north and south of the subject property. Submit as preliminary site plan for review and approval. Limited to the current owners or applicants, Arthur J. and Dory D. Vizzi, and their first-generation children, and shall not run with the land. Shall expire if the property is sold, transferred, or sold, in which case the conditional use becomes null and void. This is your legal challenge typical condition. If there's a third-party challenge, it's quite long. This is another condition that has to do with successful legal challenges. This is your typical revocation condition that goes on all your conditional uses, which you just heard many of them here, and special exceptions, which is the potential for a revocation if there's a violation of the conditions of approval by any of the means in the Land Development Code 108 or going through the revocation process. And this is a typical condition that talks about the fact that the conditions are not severable. And this is the request that the acknowledgement form is signed.
Okay.
That's what I've got.
Mr. Williams is here.
Excellent.
So will you set
Did
this
planning
aside a
commission want
minute?
to suspend this for a second? so we
Yeah,
can take
let's
up-
set this aside a minute. Let's take up the
Thank you.
other ones that we missed.
So I think you need to at least read PC 3, 4,
Okay.
and 10.
All right. Going back to item PC3, PDD 207442, special exception in the name of Fair Happy Therapy Services, Inc., for a private school in an AC district. This comes to you with a recommendation of approval with conditions as contained in your agenda packet.
Okay, is the applicant present? Anyone here to object? No objections? Any
I-
comment? No.
Item PC4, PDD 207437, it's a rezoning, Amanda M. Bray, AKA Simmons, for a change in zoning from an RMH Mobile Home District to an AR Agricultural Residential District. Comes to you with a recommendation of approval.
All right, the applicant present? Anyone here to object? No? Okay,
And item PC10 is PDD 20CU05, conditional use in the name of Fern LLC for multiple family dwellings in a C2 General Commercial District. This comes to you with a recommendation of approval with conditions.
and the applicant's present? Anyone here to object?
Mr. Chairman, I'll move for approval PC 3, 4, and 10.
All right, you have a motion to approve 3, 4, and 10.
Second.
A second, further discussion? All in favor?
Aye.
Okay. Thank you. Thank you for your patience. Right there.
Okay, so Mr. Chairman, we're now reopening the public hearing on PC 12.
PC 12, right. Mhm.
And that concluded my presentation.
Okay.
Before we start, I just want to, there is an ex parte form in the packet for Mr. Girardi. I just want to make sure there was no other ex parte meetings that are not in the packet.
So I was requested to meet by Ms. Geiger, but she never met with me.
Yeah, those requests for to meet
Yeah.
are in there.
I see
Attached.
that.
But I just
They're
want
all
to make sure there's nobody else that had an actual meeting other than Mr. Girardi.
No.
Okay. But then we're good.
Okay. Okay.
Good afternoon.
Before he starts, I have a question of the staff,
Oh, sure.
if that's okay.
Yeah.
Denise, so this item came about because there was a code violation, correct?
Yes, there was a complaint placed into our citizen services code enforcement, and code enforcement officer went out, saw that there was development without a permit. In order to remedy it, you have to get a site development permit. In order to get a site development permit, you need to get a conditional use. Yes.
There was a letter in there, one of the correspondence back to it, a letter of objections that stated that as they were writing the letter, there was, they were listening to the range being used. So do we know if the range has been used since they were cited, and are they allowed to do that?
I'm going to answer the first question, which is the range is being used since they were cited.
Okay, so David, help me remember here, is that,
So technically, they would be in violation because they don't have the conditional use approval. But that being said, we typically will not take enforcement action if they have a application in to get the approval. I mean, they're kind of proceeding at their own risk by operating while there's a pending approval, but typically the judge won't rule on it if they know they're trying to come into compliance.
so they're sort of allowed to do that?
I wouldn't say that they're allowed, I would say that we're not taking enforcement action to stop it. I wouldn't say that it's a legal use of the land because they don't have the conditional use approval. But we are not actively taking enforcement action to stop the use.
All right, okay, thank you. Thank you, Mr. Chairman.
Okay. You the applicant? You want to state your name and address, please?
Absolutely. Good afternoon. My name is Matt Newton. My address is 101 East Kennedy, down in Tampa. I'm an attorney at Shoemaker, Loop and Kendrick. I'm going to kind of go over a little bit of what Denise or Ms. Hernandez had already said, but just some background here. The Vizzi family, who is sitting here in the front row, Ms. Vizzi's in the back. Their daughter is a competitive skeet shooter. She's one of the leading skeet shooters in the state, and she's preparing for the 2020 Summer Olympics. And a letter here from the USA shooting team talking about the importance of regular practice for Ms. Vizzi. So we have continued to be using the range while this process goes on, but we're thankful for the opportunity and for staff working with us throughout this process to get everything straight. The Vizzi family
Can I
had
stop
been
for a
looking.
second? Are you asking us to receive and file that letter or not?
Oh yeah, I will submit this to the record.
Move
once-
to receive and file.
Okay. Can you go ahead and give that to the clerk so we can get it?
Absolutely.
Thank you.
We have a motion, do we have a second?
Second.
All in favor?
Aye.
So with that background, with the necessity to continue practicing, the Vizzi family had been very interested in finding agricultural property with which to use for their daughter to practice their craft. She practices several hours a day, and an interruption in practice can be devastating to her preparation for competitiveness. So after considerable search throughout the region, they did find 52 acres of property in Pasco County, off of Bellamy Road, and went into discussions to purchase it. They had reached out to the county and understood that as long as the property was not being used for commercial uses, they were fine to continue practicing on that property. And commercial uses, the specific example was, are they using it for lessons? So with that mindset, they went forward and assembled this skeet shooting range here. As Ms. Hernandez described, the facility has two components, which is a high house and a low house. Within each of these sheds are remote-controlled target launchers. They launch little orange discs, and they're also used to contain supplies for the cow grazing that's been going on the property for some time. In addition, there's these concrete ranges or shooting positions in between. Now, when they received the code enforcement warning, their mindset was, well, we can either tear this down or go forward with the conditional use, of the understanding that we can agree to some conditions on the property, and a lot of those conditions we agree with and we'd like to see attached, and there are some that we disagree with. Now, if we can't go forward, the only options for her to continue practicing are with these traps on a tripod. And this is not an ideal situation. It wastes time to set up. It doesn't create these same competitive conditions that the actual a competitive international standard skeet shooting arrangement does. Instead, it creates a lot of moving parts. It's not as safe. It's not as predictable. As Ms. Hernandez had pointed out, the location is located right off of Bellamy Boulevard, south of Johnson Road. The zoning designation is agricultural. The future land use designation is agricultural as well, with a density of 1 dwelling unit per 10 acres, which is one of the least dense portions of the county. It is located in the rural transition area of the county, which is an area designated to transition between Area 1 here and more intense urban uses. So while this is in the agricultural and rural overlay, it is meant for more intense, more urban uses. The site itself, the site is located about 1,600 feet off of Bellamy Boulevard. It's not readily visually ascertainable from the road. It's set back quite a bit of ways. And there's some limited screening existing to the top, to the north, but a condition that we're willing to go forward with is to put more privacy and visual screening along the north and the south areas, where we understand there are concerns about the consistency. We had the neighborhood meeting on July 1st, and noise was a significant concern. And as the letter you had read pointed out, it is audible. We've done some exploring on ways to mitigate that, and frustratingly, we can't afford it. The condition that's being requested is a 20-foot berm. Based on our research, the cost to build a 20-foot berm of that nature would cost between $65,000 and $112,000 along the north and southern perimeter. And further studies conducted by the U.S. Department of Transportation, while it is very difficult to reduce decibels by 15, it's almost impossible to reduce it by 20. So to invest $112,000, even if we had it, our position is that it wouldn't do much good to mitigate the noise. The best methods of mitigation, in our opinion, is to limit the hours. And we are ready to limit those hours to none before 9 a.m., none after 4 p.m., as well as no shooting on Sundays. Additionally, we've not shoot on Good Friday, Easter, Thanksgiving, or Christmas Day. Our promise to run with the land, that this will never be used for commercial purposes, just for the Vizzi family, to practice for her competitive skeet shooting. We'd freely work with the Department of Environmental Protection to put together an environmental plan and let that be governed by the Department of Environmental Protection, and work with Denise and her staff to put together reasonable privacy screening between the property to the south and the north so that they don't have to look at the shooting range all day. These are the conditions in addition to the boilerplate conditions that we can talk about with staff that we're willing to commit to mitigate the off-site impacts of this range. That's our presentation. I'm happy to answer any questions before or after public comment.
Well, my first question would be the items that were listed by Ms. Hernandez in terms of, I guess for lack of a better word, limitations. Do you object to any specific ones there?
The 20-foot berm is a big concern for us. I do have concerns from a legal perspective that I can talk to about with the county attorney's office about indemnification for legal challenges, for attorney's fees and perpetuity. That was something that we're concerned with.
What would you put in place of a berm? 20-foot berm.
Well, the berm, frustratingly, is the cheapest option. The average cost for a lineal foot of a 20-foot berm is $6. That's opposed to a mixed linear cost, which is about $21 a foot. But the massive size of this site creates a cost-prohibitive proposition. So pardon me, I guess I'm going backwards, or unless, that's the next recommend. Our sound mitigation strategy is to limit the hours.
What is the total cost of the berm?
I'm sorry?
What would be the total cost of the berm there?
For a 20-foot physical berm, the average cost produced by the federal government in 2010 would be $65,000 for a berm. For a mixture, which would be a berm wall combination, would be $112,000, and that's average back in 2010, so those prices may have fluctuated.
Okay. So is that the only thing you're objecting to?
We are objecting to the language of the environmental one as written.
What is it?
But that's only because we have a preemption issue. We're concerned with the wildlife survey, the cost of that. To have it be running, not have it run with the land, but run just with the family. I mean, that's something we can discuss, but that's something that we've not been a fan of.
Do you have a red line or something of like, that shows what, I mean, because it's difficult for the planning commission to react to what you're typically, you know, if Barbara Wilhite was up here, she would give us a red line, okay, that shows what you're willing to agree to and what you're not willing to agree to. We don't have that. So do you have such a thing that shows kind of a strike through and underline of what against what staff proposed?
I do not. I can provide that between now and the BOCC hearing.
Okay, I'm just saying it's going to be very difficult for the planning commission to vote up or down on these conditions without knowing. I mean, you're making general overview statements about objecting to part of this condition or part of that condition.
Sure.
That's very difficult for this body to react to without a red line document that shows exactly what language you're objecting to.
I suppose an option we could do would be a recommendation based on, yeah, I hear what you're saying. We could recommend, we could base a recommendation to approve conditioned on I suppose the most practical way would be to recommend denial.
Well, I mean, if the planning commission is inclined to deny it, it doesn't matter.
Right.
Okay. But if they're inclined to approve it with conditions, they could just go with staff version. Okay,
Sure.
But you're saying you're objecting to all or parts of staff's version. I'm only pointing out that it's difficult. You're just making generalized statements here about not liking this condition or some, I mean, just, but for example, the indemnification, you said you had some concerns with it. I don't even know which part of it you were concerned with because you don't have a red line.
Sure.
Hours of operation, it sounds like you're generally okay with it, except for some holidays you're not agreeing with. So my point is that's difficult for us to react to up here without a red line. So, I mean, I think regardless, we need to conduct the public hearing. I think it's going to be difficult. I mean, we don't like to invent these things on the fly up here trying to do wordsmithing. That's why we ask, if you've got changes to conditions, we get a red line so we know what we're voting on.
Sure.
And we're not talking about just one condition here. You're talking about the entire set of them.
Sure.
So,
Yeah. I understand your concern.
I mean, maybe we could have the public hearing to see if planning commission's even inclined to approve it, but we may need to continue it to work out these conditions because we don't there's nothing for them to act on at this point,
I understand your concern.
if they're even willing to approve it with conditions.
We would agree to a continuance on that basis.
Okay, well, regardless, we need to have the public hearing, but I'm pointing out to you that I think it's going to be difficult. I mean, unless the chair says otherwise, I think it's going to be hard for them to vote on something where they don't know what
Yeah.
language they're voting on.
Yeah, I think that's exactly right, and, you know, and I think, I mean, my observation is that the staff is obviously trying to work with you, and give you some conditions that, you know, I feel for the most part are quite reasonable. So I think they're trying to work with you and make it
Yeah.
work for you, but, you seem to be resisting it. We don't really know where you're trying to go with it, and I think it's a little bit confusing, and I think David's right, you know, we need something a little more solid to look at that we can tell them, hey, possibly the best thing to do would be continue it.
Okay.
Well, since there's people here to speak to it, I think you should hear the public on the matter.
Yeah.
I don't want the applicant to, or the public to believe that there's likely to be a vote today, given where we stand on this condition. Unless it's a
Go
vote for
ahead.
denial, because that wouldn't require any condition.
So during his presentation, he made a statement, go back one more picture, please, that if this is not approved, then they would be forced to utilize this, what I'm gonna call a portable skeet shooting machine. Does the county agree with that, that if this isn't approved, that they can still use this to shoot?
So this gets into a nuance of the state law on guns. And Mr. Newton and I have had many conversations on this issue, but generally, the state law is that if you're just shooting a gun out there without any infrastructure, we're preempted. We can't do anything about that to regulate it. So if she was just out there shooting her gun and there's no infrastructure, there's not much we can do. Again, we didn't create this state law, this is something the legislature did, but there's an exception for, quote, gun ranges. So the issue is what constitutes a gun range. Our historical position is if you're putting in infrastructure of any, if you're materially altering the land, if you're engaging in development, and it results in a gun range, that's a gun range. So if they were putting up berms out there and they were shooting into the berms, that's a gun range.
But also, would it be if it's for commercial use?
Our code doesn't really, I don't think the state law, Mr. Newton disagrees with me, but I don't think the state law distinguishes between commercial and non-commercial use. It's really, is it a gun range or not? So to answer your question directly, that device likely would not be construed as development. It's not materially altering the land. It's a machine on top of the land. They're not building a berm. They're not putting little houses out there, or they're not doing anything to alter the land. And so we likely would say that's not development, and therefore we can't regulate it if they chose to do it. Okay, and I'm not saying this law makes sense, okay, I don't want.
Well, a lot of what comes out of the legislature doesn't make sense.
Because I'm not sure that from the citizen's perspective, it's materially different, that versus but we're stuck with what the legislature has done to us, and they said, we're preempted unless it's a gun range. Our position is it's a gun range if they're engaging in development of the land. If they're not engaging in development of the land, it's very difficult for us to say that that's a gun range.
So what our position is, because they've built these two structures there, that they have developed the
Right.
land.
If they had not built all this right here, we likely would not have cited them. Is that right, Denise?
That's correct.
So if all they had was that little machine that you saw in the other picture,
Okay.
they likely would not have been cited.
Well, the fact of the matter is, they still be shooting guns, and it sounds, at least the letters of objections, and I'm waiting to hear the testimony from the public, but the letters of objection are around the fact that they're discharging weapons out there.
Yes, but some of that is, the mere discharge of weapons is not something we can regulate,
Right, I get that.
because the legislature told us we can't.
Right.
However, we can regulate gun ranges. That's the
Okay.
reason this is before you, is because they built a gun range, and Mr. Newton is generally accurate that if they dismantled it and just did this, there's not much we could do.
Okay.
I'm not saying because we wouldn't want to do something about it, it's because the state has told us we can't.
No, I get that, but so by going through this process and having at least some conditions, would appear to me that that would be an improvement for the surrounding neighborhood or neighbors. I mean, and specifically the hours of operation that they're allowed to do it versus, all the time. So it would seem to me like by going in this direction with some conditions on it that are acceptable, the neighbors are in a better position than they currently are now, or will be
And I
with that.
suspect that is why staff is recommending approval with conditions.
Right, okay, that makes sense. Thank you.
Okay. You have anything else you want to add, or any more questions from up here?
Not at the moment, happy to have the
We'll hear from
public
the
come up.
public. Okay, who would like to come up and speak on this topic? Okay, if you're going to speak, get ready and come on up and The closer you are to the front, the better off. You'll have a chance when,
Well, she's technically, did you use all of his 12 minutes?
you're,
Okay, do you
I'm
want to
sorry.
give some of your 12 minutes to her?
you're with the applicant. I'm sorry.
Okay.
Okay.
Hi,
Hi.
my name is Danya Busy. I am the skeet shooter.
What's your address? I'm sorry.
15615 Shoal Creek Place
Okay.
in Tampa. I'm a 4-time world championship medalist, 2-time national champion, just medaled at the Pan American Games, and as of last week, I am halfway onto the Olympic team for 2020. And I just wanted to tell you guys how much it means to me to keep this here, because this is why I've been able to medal at the Pan Am Games recently, halfway make the Olympic team. And I just really needed to train, and this is my passion. This is what I love to do. I want to, compete for my country as long as I can, and I would just love your help with it. On agricultural land, you can shoot whenever you want. I mean, that is a Florida, right. It's a Second Amendment right, and I just feel like I'm being penalized for building a more immaculate field than just the little stand that he showed you. And I am trying to be courteous. I do shoot between 9 and 4 every day, and I have taken every Sunday off since they said that. And also, somebody asked me to not shoot one day, and I didn't. And I'm trying to be courteous, but I have to do my job as well. And yeah, thank you guys. That's about all I have to say.
So can I ask you a question? Do you shoot 6 days a week?
Not anymore. I shoot 5 days a week.
5 days. Okay.
Oh, sorry, 6 days a week. I don't shoot 7 days a week anymore. I take every Sunday off.
Okay.
Can I ask a question too?
Sure.
The condition that talked about a limit on the number of people that can be there, first of all, are you all in agreement with that? That it's a maximum of 4, are you all okay with that condition?
No, that's not something we would readily accept at the moment, but we're willing to continue talking with staff.
Well, I guess that's the root of my question, is how many people what's the maximum number of people that would be out there shooting at any one time?
So I have to have somebody who pulls the target for me, so they're not actively shooting, but they have to be on the range because they have to hear me. And then sometimes I have somebody pulling for me, and also my co-chair watching me, so that would technically be 3 people on the range. And I have had a friend come out and shoot with me before. So that's about it. But
Yeah, Matt Newton again. Typically, the average is 3, which was used for the traffic and impact study.
So if you're never having more than 3, what is the objection to the limit of 4?
It's difficult for a property owner to take on burdens that aren't necessarily necessary. And it could create confusion if there had 2 people out there one day, in addition to the team. So with the 5, suddenly we're out of compliance.
Well, but then you make a representation for traffic purposes that it wouldn't be more than 3?
That is the typical representation, yes, sir.
So
Historically.
if that was your representation to staff, what's the objection to actually limiting you based on the representation you made to staff?
As an attorney, I feel caution with creating conditions on a property that may fluctuate in the future. Now, I'm not saying 20 people there, 30 people there, but if we have a condition of 4 people and one day 5 people show up, we're out of compliance.
Well, I mean, they could change the condition to 5. I mean, that's why I'm asking the question.
Yeah, I mean,
If the objection is the number 4, I mean, planning commission could change it to 5 but for you to say we have an unlimited number, even though you represented the staff, it would be 3, that's not atypical for the planning commission to limit the number if your representation was that it would be a limited number.
If it's the pleasure of the planning commission to put a solid number on there, we're happy to discuss that.
Okay, but in general, you've never had more than 4?
no.
Okay, answers my question.
Okay.
I guess while you guys are there, I got a couple of questions just for you. Obviously, your address didn't sound like it was here, so you don't live on the property, you come to the property every day?
Yes.
is there not a range like 10 minutes down the road at Tampa Bay Sporting Clays? They don't have what you do?
They don't have a ski field. That's Olympic style. It's not like, the stations aren't in the right spot. So it would be honestly worse for me to train there
Okay.
than to not train at all.
I just wasn't sure. I've never done
Yeah,
it. So I mean, I've
definitely.
been out there, but I didn't know what, they do have
Yeah.
that separate area to the side of the picnic pavilion, but I thought that was what that is, but.
Yeah, it looks like that, but it's not in the right spots. Because they didn't have enough space to make it as big.
Okay.
Okay, it's like
That's all for now?
like having an Olympic pool that's about 20
Not
feet
really
too
Olympic
short.
pool? It's a good way to set a world record.
Okay.
Thank you.
Anything else from the applicant?
I believe Mr. A.J. Vizzi, Dania's father, would like to speak briefly.
Okay, can you state your name and address, please?
Arthur Busy, 15615 Shoal Creek Place in Odessa, Florida. My name is A.J. Vizzi. I'm Donnie's dad. My wife and I purchased 50 acres off Bellamy Brothers in an agriculturally zoned area for a ski field for Donnie to practice for the upcoming Olympics. Before we purchased the land, I researched the zoning standards in Pasco County and read about the conditional use of outdoor firing archery ranges. So I called the county to see if it applies to a private ski field for our daughter. It took me about 4 or 5 people before someone said, "Oh, I know who you need to talk to." And he gave me the number for a man named, and I don't know if I'm going to pronounce the last name correct, but a Mark Derricott that works for Pasco County, who understood what a ski field was and told me that I wouldn't need a conditional use permit unless Dania would ever want to teach or coach somebody out there, or if we were going to charge people to come in and shoot on it. You know, he said you might want to consider doing this at some time in case after she, you know, practices and decides not to shoot competitively anymore, that if she would want to coach. Now that we purchased the property and started practicing there, the county decided that we needed the conditional use permit because the houses we erected were land development, when we actually just built them for 2 reasons: storage for our, you know, like farming equipment that we use, and for cattle feed, and for the purpose of putting these machines in to keep them dry. When we originally met with staff after we got the citation, we were led to believe that applying for the conditional use permit would be the easiest solution to our disagreement that using a private field we had was our right of landowners in this state. So we applied for the permit, and right before the scheduled meeting 2 months ago, we had seemed to have negotiated the conditions that would be supported by the commission. Then right before the hearing, the day before, or the evening before, we were told that they weren't ready and would have to postpone it for a month. Then the unreasonable conditions started to come. Conditions that would be fine for a company that wanted a commercial range with multiple fields and would have income to be able to afford what the conditions they're asking for. They are cost prohibitive for us and therefore unreasonable. I get it. Some people are complaining about the noise from the report of the gun, but most of our neighbors are okay with it because it's not any different than what they hear around them all of the time. In fact, the biggest complainer, and Miss Ann McKinley, who I'm sure has written you all letters, thinks it's okay for her family to shoot on their property and not my daughter. It's funny how the noise doesn't bother her when her son's shooting out there, but it bothers her when my daughter's shooting out there. You know, we're willing to limit hours and days to help with this. We're asking for your support in helping Donnie achieve her goal, a dream of making the 2020 Olympic Games, and bring a gold medal back to the USA and Pasco County, but we can't agree to conditions that are beyond our capabilities. Thank you.
Thank you.
Matt Newton, no more for the applicant at this point. Thank you.
Thank you. All right. I believe somebody had their hand up back there. Want to come forward and state your name and address?
Sure. Good afternoon, Commission. My name is Glenn Stevenson. I reside at 16653 Bellamy Brothers Boulevard. My property is at the adjacent to this property at the back. Before I go into my preamble, I would like to show you a video that was called Sunday Gun Day on Instagram, and it has no relationship with skeet shooting. it has a relationship with an AF-15. Now, shooting an AF-15 requires a burn. Now, this is on a social media site for people to see that this young lady is not only a great skeet shooter, but very efficient with her AF-15. And I find it quite reckless. So, what I'd like to say, I have some concerns and recommendations. The first thing I'd like to say is I'm not here to kill somebody's dreams to be an Olympian. That's not why I'm here. I find it interesting that they can quote all these awards, but they haven't just happened. They've happened before they purchased the property as well. So this property isn't key for success as an Olympian, because she's already been a national champion. So my business has been impacted negatively. I have lost people that boarded horses with me that are very expensive brood mares. I run a breeding program. I have a reproduction lab at my farm. Originally, they told me it was going to be 2 hours a day. It was more like 4 to 5 hours, 7 days a week in our direction. I can actually hear it in my house. I'm the closest property to their property, and I get all the noise in my house. I have tried to coexist with the applicant, but the reply was negative. They said that the neighbours were verbally abusive. Well, that was not me. I don't know about my neighbours, but I never got into a verbal confrontation. So I would like to see 5 days a week, 9 till 4, 2 days off, and keep to the holidays that relate to Florida. I have also boarding horses that want to ride their horses that can no longer ride up into that far corner of my property. I don't have a pen to point it out, but it is, maybe you can show them. Oh, is that it? Okay. Okay. So I'm here and here, and I have people riding horses up in the area. You know, I need to know what are they going to, how can I reassure that there's not going to be stray bullets when people are riding horses? I can't turn my mares and foals up into that pasture land anymore because it does spook them. I'm not saying it spooks them all the time, but it is very noisy. I don't want it to be a commercial entity. And if the property is sold and it needs to revert back, I'd like it to see that it's going to be assessed for that portion of that land, whether it is greenbelt anymore. You know, because it's 53 acres, but there is a portion that is not greenbelt. It doesn't conform to greenbelt if you're going to not raise cattle on it or cut hay. And so the whole property needs to be reevaluated for greenbelt. So I'd like that reviewed by planning.
Sir, just to be clear on that, our planning department does not determine the greenbelt.
Okay, I understand.
That's something the property appraiser does.
Okay, all right.
And so you would need to file that complaint with the
Okay,
property appraiser. There's
thank you.
nothing this body or our staff can do about the greenbelt status of property.
I appreciate that, thank you. This meeting, the reason we're here today is because the applicant went ahead and did what they wanted to do. You know, they got this name of this individual that they spoke to that said you don't need to have a conditional use, yet nobody seems to know this individual. I found their application letter back in April 29th.
Your time's up.
Sorry?
Your 3 minutes is up.
Oh. Well, that's it then, I'm done.
Yeah,
All
we
right.
got the idea.
All right, thank you.
Thank you. Okay, who else would like to speak?
My name is Judy Geiger. I live at 16225 Bellamy Brothers Boulevard. It is the property due south, adjacent to the property in question. Let me just clear up a couple of things that I've heard over the past few minutes. This property is not a half a mile east on Johnston Road. It's west of Bellamy. If it was east, it would be in the northeast Pasco Rural Protected Area. It is not. It is in the northeast, it's in the rural transition area. The other thing I want to thank Denise. She's worked very hard on this piece of property, and thank you all for bearing with us on this. There are other skate ranges available. There's one not too far away, Tampa Bay Sporting Clays. There's one close to where the Vizzies live, which is called Silver Dollar. I understand they applied for a skeet range down there that was Olympic, and they were turned down. The other question I brought up about the berms of being $65,000 to $120,000, they paid over $500,000 for this piece of property, and then they put another $150,000 into the skeet range. So they're already into it for $650,000. So what's another few thousand to make it happy for us? Okay, I got a little bit of presentation here. Would I use this? I don't know how to use it. Just nope, wrong one. Yeah. It's okay. I'll show it. Okay. I don't want to push all the buttons. Okay. Good. Okay. This is what a skate range looks like, but you've seen the photo of the one that they've actually got on their property. These are my main concerns: noise, the contamination of the ground and water, projectiles and litter escapement, and property devaluation. The decibel levels on a jet aircraft is 150, chainsaw and a thunderclap 120, garbage disposal 80, quiet rural area 30, a shotgun 12 or 20 gauge, I don't know what she's using, I think she's using 12. It's 156. That source came out of Temple University in the year 2000. Contamination, that's a picture of a shotgun shell on the top. The problems are the lead shot, the wadding, and the plastics. Over the course of the conversations, Ms. Vizia said she picks up the shells, but the lead stays in the ground. And skeet ranges can contain up to 1.5 billion pellets per acre, and that's the source. It's a hazardous waste expert, and they posted it in Sports Afield magazine in 2014. The projectile and litter escapement. I personally have picked up pieces on my property, and to which I've been called a liar by a representative of the Vizzies. This is deadly to both cows and horses, and I couldn't find any documentation, but I've talked to some local cattlemen, and they will not even cut hay on that property for the pieces of the targets of the projectiles. The last thing is the property values. These are quotes from Realtor.com, Remax, and a website called Pocket Sense. A buyer will think twice about buying property next door. The lead shot and the dust concerns. The valuation is actually down 3.7%. And who wants to live next to gunfire noise? Okay, this is some of the things that I would like to see. But you talked about the number of people. Okay, I would say put it down to 2 out there, if you do elect to go forward with it, which I hope you don't, because I don't want this thing next door to me. Take the people shooting, not on the property, to 2, her coach and her. The hours of operation, and I've talked to Mrs. Vizzi about this, and got nothing but excuses. If they could come out half a day, that way I know that I can walk my dog in my dog runs inside. Today was the first day she's been out there shooting again. I put my dog outside, he ran right back in. I'm a Florida Master Gardener, I can't be out working on the garden. I don't know when she's going to be there. So if we could limit the hours to half a day, then I know I could be out in the afternoon or whatever. And I didn't see it earlier, it's no legal holidays. On condition number 8, we need to add the length of the berm. We're talking about just the height, but we need to go length, which would transverse the length of the shooting facility on my side and on the north side. I'd like to see a condition added to exclude all firearms except a skeet shotgun. I'd like to add a condition that they require a toilet facility on the property, which they do not have anything. Go back to the old country way of bushes, I guess, except there's no bushes on this property. Okay, this is some quotes out of the comprehensive plan for Pasco County. Implement and enforce this policy.
So
this
can
is
I-
the goal.
Ms. Geiger, can I can you go back to the prior slide? So I'm going to give you the kind of the same lecture I gave the applicant, which is it's difficult for the planning commission to react to these kinds of, just do X, Y, and
Understand.
Z. So if this gets continued, it'd be preferable if you gave, and you can ask Mr.
Did a
Nance
red
for the
line.
word version of the conditions,
Okay,
where you redline them and show exactly the
I can do
changes
that.
that you're requesting. I don't know what they're going to do with it, but
exactly.
it's hard to react to these generalized statements about the conditions.
Okay, I didn't know how to do it. I'm not an attorney here.
That's.
Okay, but
you
I
have a
will
little more
correct
of
it if
excuse
it
than
does
the
get
applicant does, 'cause he
continued,
is
or
an attorney,
before the
but-
board
but-
meeting.
But I'm just pointing out the same
Very
thing,
good.
that this is more helpful if we have a red line.
Okay.
Thank you.
Okay, the goal of your comprehensive plan is to implement, enforce policies and programs to design, to preserve and reinforce the positive qualities of a rural lifestyle and protect rural communities and agricultural areas. This is in the rural transition area. Okay, policy FLU 2.1.7B, methods of protecting rural neighborhoods from the sensory intrusions of adjacent non-residential uses, and she stated that this is her job, so that's not residential, that may affect the long-term viability of the neighborhoods. Sensory intrusions include unwanted light and noise, physical access, odor, and other sorts of disruption. Okay. The applicants have displayed a history of not following the rules. No building permit, no rezoning request prior to their actions. If I had been in the same situation, out of respect for my neighbors, I would have ceased the shooting activity, gone and done the things right, and then come back in. But that doesn't happen with this family. Therefore, as part of your decision process, I encourage you to delay approval until the following are completed. A BMP, best management plan. The Florida Department of Environmental Protection has a whole manual on how to do this. They need to complete the wildlife survey with the Florida Fish and Wildlife Conservation Commission or with the U.S. Fish and Wildlife Service. I'd like to have them obtain all other permits as they noted in condition 4. Okay, I ask you to deny this. This is not what belongs out in that area. Thank you very much.
Can I ask a question?
Any questions?
Judy, the county attorney has said they shoot all day, 7 days a week with this portable device. So if we approved it with conditions, aren't you better off than you would be that if we denied it?
I don't want it to happen at all. I want it gone.
But that's not a reality, because the state law says that they have the right to do that.
They have a right to shoot, but I think you could be challenged because she is out there literally up to 6 hours a day, constant shooting. That's not hunting a deer or, sighting your gun. My son owns property across the street, and he has hunters on the property, but it's constant. You heard her with the AR rifle. A skeet round is 25 shots, or 25 stations, I believe, and that's 2 shots. It's constant. Yeah, I know what you're saying, Mr. Cox, but
I mean, I'm just trying to,
I know.
wait.
I just don't want
I got an attorney telling me that, if they
Yeah.
use these portable devices, that there's really nothing that can be done.
No,
And at least with this, we could condition it to some hours. It's an agricultural property, and
there's also nuisance laws, Florida Statute Chapter 60 that I did not bring up.
So to be clear, you can bring a private nuisance action.
You bring a problem?
You have every right to sue them in a private nuisance action. But the legislature's preempted us, the government, from regulating shooting. We're not preempted from regulating a gun range, but if somebody just goes out and shoots a gun, your elected state legislatures have decided that we cannot regulate that. As much as you would like us to, we cannot.
Okay.
just like we can't do anything about fireworks.
So,
It's not a big deal in agriculture.
Yeah, but I can come to y'all and
50
say, I
foot
don't
lot
want
it
it.
is.
And yeah, I know there's legalities and stuff, but as a citizen, I do not want this sitting right, it's right next to me. I think I don't even know if she's 25 feet off the property line that they're required to be.
But I guess what I'm pointing out to you is
I understand.
you have more rights than we do. You can bring a private nuisance action and sue them all you want and claim that all the negative impacts that you have, but because the legislature didn't preempt your ability to do that. They preempted our ability to do that.
Okay. That's good to know. Thank you.
Okay, thank you. Anyone else?
Good afternoon, Mr. Chair and members of the Planning Commission. For the record, my name is Philip Rhinesmith, 16833 Bellamy Brothers Boulevard. Permission to give a copy of the presentation to the clerk, recorded in the record.
Receive and file.
Thank you.
Motion to move it here. Move it file. All in favor?
Aye.
Thank you. Our family, extended family, and you'll be hearing from other members of it, manage 120 acres directly adjacent to the Vizzy property. As you've heard, our primary concern is the noise generated from the range. Most of it is the duration. But I want to touch on the environmental conditions that Judy Geiger touched on. So to put that into numbers, typically in a round firing 250 rounds a day equates to about 15 pounds of lead on the ground. The accumulation over a year's time could be 5,000 pounds a year. So just to put that into perspective. We're concerned about the long-term impacts. Again, we have a working farm. Lead shot is composed of course, lead. Antimony does contain arsenic. Again, that's just for discussion, not the main reason that you'll hear the noise concerns. So as we discussed at the on-site meeting with the Vizzy family and their council, there have certainly been quality of life impacts, and you've heard some of those from the noise and the duration of the range. To measure and document some of this noise, we measured noise at various locations on our property. Sampling probably 2,600 feet from the range, there was a 30 decibel increase, and I think Ms. Geiger pointed some of this out again. You may hear some of this information a couple times. And remember that that decibel increase is approximately 1/2 mile from the range. Mr. Vizzy touched on an important fact that while shooting sports are common on agricultural lands, it's not the fact of the shooting, it's the duration. Typical recreational shooting on properties only lasts for an hour or two, and that's for, just a couple of days a week or on the weekends. Typically, we're listening to 3 to 5 hours a day, up to 7 days a week. Typically, recreational shooting ranges in West Central Florida, every single range has at least one day that are closed. Shorter hours on a couple of days, and again, done out of respect for adjacent landowners. Again, considering that they're in violation of county code and they continue to shoot. That's all I have. Thank you for your time.
All right, thank you very much. Any questions? I guess not. All right, anybody else like to speak? Please come forward. Don't wait. Just come on up.
Ms. Rhinesmith has 6 minutes.
I won't use up 6 minutes, but if we have time, I do have the video that I'd like to show. I also have mine written up for the court, if you don't mind.
Okay.
Move to receive and file.
Second.
All in favor?
Aye.
Thank you.
Can you state your name and address, please?
Yes, sir. Good afternoon. My name is Robin Rhinesmith. I live at 16833 Bellamy Brothers Boulevard, Dade City, Florida, 33523. We have 3 generations of family living on our farm, which we've called home for about 50 years. We pay many taxes over the years with Pasco County and haven't requested a single thing until today. The trade-off of rural living surpasses our need for community services and amenities. We love our property, and we are proud gun owners as well. I would like to use my time to focus on 4 of the 8 standards that were contained in the conditional use application. I'd like to read the standards and then provide my commentary. Standard 1 was the proposed conditional use will not adversely affect or contribute to the deterioration of quality of life or property values in the immediate neighborhood. I speak for my family who is on the receiving end of the activity. She shoots north, and we are the neighbors to the north. The intense sound that propagates from her high-power rifles goes right through our homes. 30 decibel spikes off of a noise meter over a course of hours each day. I would like the county to play a video clip of a mere 8 shots within 44 seconds. So try to imagine what hours, not seconds, is like when you live in this location. Your home is your safe place. Your property is your safe haven. Yeah, go ahead. So, okay, this is a noise meter, if y'all have ever seen them. I work for a state agency and have been a noise specialist for almost 30 years in the state. But this is a piece of equipment that somebody I know has, and this basically shows that your background noise average for rural is around 40 decibels, and the spikes go up between 20 to 28 decibels. You can see the spikes there as you go along. There's a bird singing, so of course that's in there as well. That was pretty short, but anyway, gives you an idea. It's certainly different when you're right there. All right, so we live amongst nature, beautiful live oak trees and pastures. We spend less time outside, not because we're lazy. We have a 120-acre farm that we try to run, but the feeling of living in a battle zone overtakes with each shot that's fired. Using earplugs on the tractor doesn't even drown it out. My mom is 90 years old. She doesn't get to rest like she used to. We are adversely affected. Our blood pressure increases and anticipation sets in as we wait for the next round. We're edgy, and we try to enjoy and have peace and quiet, but we just don't know when we're going to get it. My daughter was a competitive equestrian for many years. She has sadly quit riding because she doesn't enjoy training on her own property. It's impossible to concentrate and perform a dressage test or a jumping pattern with a shooting range right next door. Communication with her coach is interrupted by the boom of gunfire. Standard 2 was the proposed conditional use is consistent with the character of and existing land use patterns in the surrounding area. I'm not sure how skeet range fits in. The duration and intensity of their activities is like no other around here. We have a shooting range, and we use it maybe twice a year for about an hour, and we call our neighbors before we use it. At $25 a box for 50 shells, the cost of ammunition is likely the limiting factor with most private gun ranges. Standard 5, the site upon which the conditional use is to be located has or will have screening and buffering sufficient to prevent interference with the enjoyment of surrounding properties. My parents' 40-acre hayfield is adjacent to the Vizzy property and is currently zoned 1 home per 10 acres. So theoretically, we could have 4 homes out there, which would be the highest and best use for the property. Being in the direction of gunfire with no buffer and a lead drop zone basically at your property line, would you be able to enjoy your family and pets without an impassable barrier? We can count cars and people at their range on any given day. And finally, Standard 8 states the proposed conditional use will not otherwise adversely affect the health, safety, or welfare of the surrounding community or area. How can it be discounted that there is no buffer, lead is going onto the ground, and my family's activities are greatly limited on their adjacent 40 acres with high-powered rifles aiming and firing in their direction? We can't put cattle or horses on the property for fear of them being injured or killed. We take the risk anytime we walk out on our own land, and we pay taxes here for nearly 50 years. Thank you.
Thank you. Welcome. If there's anybody else that's going to speak, you could come and sit up in front here so when we can move this along.
Good afternoon. I'm Ann McKinley. I live at 16751 Bellamy Brothers. Thank you. The first thing I want to say to everyone, we are all avid gun owners. This is not against the guns or the Second Amendment. We believe in having guns. We have guns. The Veazys bought this property. They could have bought it anywhere in the county. They could have bought it next to any of you or one of your friends, whatever. But they chose to buy in our area. And one of the issues is that they didn't take into consideration what the impact would be on our neighborhood. There is a sign right next to their property, or at least one property down, that shows it's an Arabian horse farm, Glenn Stevenson's farm. Most everyone knows that with horses, especially Arabians, that this is not conducive to them. It just is something that just is not good. And Glenn does horse breeding there. He brings in horses from outside, and this is it's been catastrophic to his farm. But they didn't take that into consideration. They didn't try to ask before they bought the property if there was going to be a problem. They didn't let anyone know, because if they had, people would have said, hey, this is going to be a real problem for the neighborhood. But they didn't ask. They didn't care. And it has become a problem. Glenn has lost business because of the noise. Our granddaughter, who tries to ride horses, has ridden competitively, can't do that. She can't have a coach come in and work with her because she never knows when the shooting's going to start. We have been on our property working in our hayfield, and the Veazys have come and charged the fence as if to try to scare us back, which makes us wonder if perhaps they feel that some of the ammunition may be going into our property. Even Larry Bartle was out mowing our pasture, and they charged the fence when Larry was out there. They stayed there for the whole time he did the whole mile lap around the pasture. He couldn't figure out what was going on. You saw the video of Dania's shooting. She was shooting towards our property, although she was shooting at a downward angle. We could actually hear a ricochet. The ammunition, as you may know, from an AR-15 can go over 1,000 feet, sometimes, depending on which ammo you're using, over a mile. We have concerns about our safety, serious concerns about our safety, because we don't understand why they charge the fence, unless it's because they want us to leave because they are concerned that they could shoot us. We have worked that pasture. My husband's owned that land for over 50 years. What are our rights? Do we have the right to live on our own land? Thank you.
Thank you very much. Anyone else? I don't see anyone. Would you like to come up and respond?
Yes, with our rebuttal, real quickly, I'd like to submit into the record our noise study that was conducted on June 9th, 2019, just into the record, along with some evidence concerning the cost of noise barriers.
Move to receive and file.
Second.
Got a motion and a second. All in favor?
Aye. And I understand from Ms. Hernandez that we only have 8 seconds. I'd like to request an additional 2 minutes to have Ms. Dade speak real briefly, if that pleases the commission.
All right.
Hi, I'm Dade Vizzi. I live at 15615 Shoal Creek Place. We did purchase our property for our daughter to be able to train. I do not want to cause problems with my neighbors. My daughter, that's not her goal. It's not our goal. It is just for her to train. I go with my daughter 90% of the time to the range every day, and I pull for her, and she only shoots 3 or 4 hours by herself. There is an overreach and an over-exaggeration going on here right now. She is a sweet girl. We would never charge anybody or do anything. And the AR video is the only time she's ever shot an AR on our property. And it was not at her property. It was the opposite way towards the ground, at a big pile of dirt. She is a very safe. She is with the NRA. She goes around and promotes safety all the time about firearms. Our goal is not to upset. Our goal is just to try to live with everybody the best way that we can. We want to shoot restricted hours. We want to help. She doesn't have a ton of people coming out and shooting with her, but her tractor is as loud as her gun. And she's one girl who walks around to each station and shoots. And she takes a break. She has a shotgun, a 12-gauge shotgun, by herself out there 95% of the time. Just think that, okay? The tractors, the pumps, there's so many loud things that are out there that are louder than her shotgun. And I can prove it on the decimals. We've had the sound check done. And I just don't understand why everybody is being so nasty. And we have been literally attacked by these neighbors. My daughter has been attacked. They have come and cussed her out. I have it on video. My family's seen it. And all we want to do is live in peace, honestly.
Thank you. Thank you very much.
Thank you, Commission. And for the record, we would be amenable to continuance to work on a red line if that's something that y'all want to consider. Thank you.
Could I ask him a question?
Yeah.
So I haven't seen it yet, but the estimate for the building of the berm, can just for the record state
Sure.
where you got this estimate
Sure,
from?
I could use the Elmo real quick if that pleases.
So what you're doing, I mean, have you actually gotten an estimate on to do the work, or is this just an assumption?
Swag.
This is so this is from the Noise Barrier Design Handbook published by the U.S. Department of Transportation.
Let me see if I can fix it.
Just focus it.
Most of the research done on this issue is done by transportation agencies, as you can imagine, by the result of vehicle noise. So this is an average cost in 2010, which has actually a 12-foot or a $12 per foot estimate for 20-foot berm. And this is by material, so you have concrete, block, wood, metal, berm, brick combination, absorptive material, and then all materials. And then in a footnote, you see a other material estimation. So while we were looking at this, these are the types of resources that we're utilizing. And this is published by the federal government.
But you actually haven't gotten an estimate on bringing in dirt
I do
to
not
build a
believe so.
berm?
No, sir.
Yeah. All right.
Since this matter is likely to be continued, is that something that is important to your decision?
I think it would be important to their decision. whether they
Yeah, I
want to
mean,
accept it or not.
I'm not apt to continue it, but
Okay, well, okay, I shouldn't have said that. I'll just stop, whatever you want to do.
so one other question, would you be opposed to adding a condition that only skeet shooting is done there with a shotgun?
I think Mr. Steinsteiner and I would have a disagreement on whether that condition is enforceable under the statute. I suppose I have enforceability concerns on that under the preemption, but that's something we can consider between.
If they agree to it in a condition, I think it's enforceable, but.
I mean, I've personally got a problem with some of the objections that you keep representing that you have when you go up here representing that all she wants to do is do the skeet shooting to prepare for the Olympics. Yet every single thing that we bring up, she wants to bring friends with her. You can't. All these limitations are not. They're not enforceable. Well, she doesn't even want to do those things. Why is it important? All she wants. You came up here and said to yourself that she wants that range for preparation to make the Olympic team.
I understand your
I don't
concerns.
think AR-15 shooting is part of the Olympic Games.
You're not gonna shoot any skeet with it, that's for sure.
It's on the range.
I think you're
The
shooting
problem is
yourself in the
she
foot
wants to
by
shoot
some of the
outside
objections
of
you're
the
raising.
range.
I
You can't
would
control
do.
that. That's the problem.
And
If
I
it's
mean,
use
I
of the
personally,
range,
I have a
yes.
problem with the continuance too, because we've represented that they're continuing to shoot irregardless of this even being on the agenda or a continuance, so, I mean, it's in the best interest of the applicant to keep continuing as long as we want. I mean, I think we need
So
to make a
to
decision
be
today.
clear, yeah, I only recommended you continue if you were inclined to approve it with conditions, because we don't have both the applicant and the opposition have problems with the conditions as worded, so if you were inclined to approve it with conditions, I would want both sides to give a red line that Denise can react to and say, I'm okay with this, or I'm not okay with that. But if you're inclined to deny it, there would be no reason to continue. I just wanted to be clear about that.
Yep, got it.
And the way I look at it is, I understand that the neighbors don't want it there, but they have other recourses to deal with that other than it being a conditional use. And it appears to me that with these conditions in place, they're better off than they are without them. So I'm inclined to recommend approval based on the recommendations, but I would like to add a condition that on the range, they're only using skeet shooting weapons.
Shotguns.
Shotguns. Right. So,
Okay, I think it's an enforceable condition if it's limited to use of the range, that the range will only
Correct.
be used for that purpose. The problem is that I don't want the residents to think that they can't just go out there and start shooting AK-47s, because if they're not using the range, under state law, they could do it. So I'm not even sure in this one instance that it occurred, she was actually using the range. So I get your point, what you're trying to do, but I don't want the residents to think that that's somehow going to stop the use of a non-skeet shooting weapon out there. Because they have all this other land, they could just, it's not part of the range, they can just go out and do that. I suspect that's why Denise didn't even attempt to regulate that. She did put a condition that says that if other forms of firearms are used, she has some additional requirements there for
which condition is
backstops.
that?
It's the second sentence of condition 6. It says, in the event other forms of firearms are used on site, that there's other requirements that have to be met. So I don't think that Denise was trying to do a strict ban on other forms of firearms. She was just saying if there are other forms of firearms, there's additional precautions that need to take place.
all right, that actually, I think, addresses the concern.
As opposed to a outright ban on it,
Right.
which is, I'm not sure going to work anyway.
I'm going to move for approval based on the staff recommendation.
We have a motion to approve. Do we have a second?
Just for the record, I don't think I vote on this.
You know you don't unless there's a tie, and
Right, and it doesn't
based on the
appear there's
current
a
planning commission makeup, there wouldn't be a tie.
I mean, I'll second that, but I mean, again, following up on what Mike said, I mean, I think that the conditions are important. I don't think I've heard any conditions that are part of what we're approving today that are detrimental to what you've represented that you want to use the range for. I mean, the berm does provide, I mean, it's a noise barrier. It you know, it's there to stop lead from migrating off your property, to contain everything on your property. I mean, there's reasons for all the conditions that are there, which is, you know, that's why I've seconded, and then I'm for approval of this conditional use.
Okay, any further discussion?
So to clarify the motion, it's a motion for approval
With conditions.
with the conditions as written by staff,
Yes,
with no deviations.
correct.
Okay.
Okay. We have a motion and a second. Is there any further discussion? If not, let's have the vote. All in favor?
Aye.
Opposed? Motion carries.
Okay, it's going to the Board of County Commissioners.
Do you vote yea or nay?
Yay.
Oh, okay.
So for those of you in the audience, this is a conditional use request that's going to go to the Board of County Commissioners for a final decision.
Good af- Good afternoon. Alexandra Laporte with Planning and Development. I do want to enter into record some of the documents that you have in your packet that we have slight changes on. You'll see those struck through and underlined. I'll give it to the clerk, and then if I may pass it around.
Okay.
There's two. There's the standards, section 1105, self-storage facilities design standards, and then the mobility fee tables.
You. Did you hand out a magnifying glass with it? Great.
Or else it'd be like twice the pages.
You trying to keep something from us?
Actually, in this case, we're just trying to show the numbers that were before and the proposed numbers per the consultant at the time of the mobility fee update. Before, we just had the new numbers, so. Okay.
Well, I think, to follow up on the Planning Commission's point, Alexander, I think if this goes to any more public hearings, you probably need to just do a PowerPoint slide that just shows the two fees that are changing.
We do at the end.
Oh, okay, all right, okay.
We
This is
summarized it,
difficult
but
to-
that's the whole
this is difficult
table.
to read, okay.
Yeah, sorry. And I wear glasses too, I should have.
Yeah, but you know what it says.
This is for the self-storage facilities design standards ordinance. It's an ordinance by the Pasco County Board of County Commissioners amending the Pasco County Land Development Code, creating a new section 1105, self-storage design standards, and amending section 525, C1 Neighborhood Commercial District, section 905.2, landscaping and buffering, section 907.1, on-site parking, section 1302.2, mobility fees, to increase the mobility fees for mini warehouse, Appendix A definitions, and other amendments as necessary to ensure internal consistency, providing for applicability, repealer, severability, inclusion in the Pasco County Land Development Code, and an effective date. Our recommendation to you today is different than the one that was in the agenda. Staff would like to recommend that we receive public comments and your comments as well, and then continue the item to the next PC hearing, date October 24th, 2019, at 1:30 p.m. in Newport Richey to allow for additional stakeholder input. That would just shift our proposed timeline for the first BCC hearing to be on November 5th, 2019 at 1:30 in Dade City, and then the subsequent BCC second hearing and adoption hearing for November 19th, 2019, 1:30 p.m. In Newport Richey. To summarize, this has started back in September 25th, 2018, and in November of that year when the Board of County Commissioners directed the Planning and Development Department to research and develop standards for looking at the self-storage use in Pasco County. Subsequently, on July 9th, 2019, the BCC found that a temporary moratorium was consistent with the comprehensive plan and adopted the temporary moratorium for self-storage facilities along State Road 54 and 56. During the BCC hearing, there was a distinction made regarding the geographic applicability of the moratorium versus that of the standards, and it did recognize that while the moratorium was the only area affected by the moratorium was the State Road 54 or 56 corridor, that the standards to be looked at would be recommended countywide. Based on the June 19th, 2019 BCC hearing, freestanding recreational vehicle boat storage had been identified, or has been now identified, as both an accessory use and as a principal permitted use. Previously, if you recall, it was under the umbrella of the mini warehouse and did not have its own definition or its own standards. PDD researched local and national examples of self-storage standards, Dade City, St. Petersburg, Beaufort County, South Carolina, Portland, Oregon, and others in Florida as well, for applicability in Pasco County in order to calibrate it and to be consistent with our comprehensive policies as outlined here. We had 2 stakeholder meetings, as well as reached out to the community at large with a visual preference survey. I will summarize the input from those meetings in the survey as well. The summary from the stakeholder meetings, they wanted us to take into consideration to leave the special exception designation or special exception use designation in C1 as is, and the carryover into C2 as currently our code holds mini warehousing. So we have accepted that. At first we were looking at other examples where many warehousing and self-storage facilities are conditioned across the board, and based on that input we reconsidered, and you'll see that in your standards. We also took into account the corridor delineation and their concerns for that, and we have addressed that, and I'll talk to you further about that. We established a minimum of a 75-foot buffer on parcels along the scenic corridor that we've defined in order to best accommodate utility and right-of-way preservation needs while still preserving the purpose of keeping the view shed intact. We also looked at typical alternative standards requests that come in with this type of development, and we've embedded already those typical alternative standards into the new standards, so a reduction of parking and a reduction of buffer requirements or building parameter landscaping that is sensitive to the nature of this use has already been considered in the standards, so there's no longer a need for alternative standards for those things. We also took into account the input from stakeholders to keep the exemptions that were outlined in the moratorium and carry those over into the standards. So you'll see that piece as well. There was a input to consider alternative standards to these new standards. And to that, we've said that we've understood our code to be a one-size-fits-all, and we would hope that this new standard starts to address the barriers that causes development. And so we have essentially 4 layers of standards if you're on the 3 corridors that we are recommending, plus a general standard. So it should really minimize any alternative standards going forward. And then lastly, the multi-use requirement, in order for it to be reconsidered, we looked at, most recently, Dade City has passed a self-storage ordinance where they were requiring any new development for self-storage be multi-use, except in the condition of adaptive reuse. And what we've done instead of, we've encouraged it and provided a setback incentive along the transit corridor if you do a multi-use. So our visual preference survey, here's a summary of it. It went out to community organizations, HOA, Chamber of Commerce, through our Pasco Media department, and it was about 10 questions, general questions along the lines of commercial development as a whole, and then we also had questions regarding self-storage specifically. In this little summary slide, you can see the types of buildings in terms of their visual appeal that was preferable by the community. We also took note that overall, 91% of the respondents wanted self-storage to be set back from the roadway to minimize that visual impact, to be well screened with landscaping, and or concealed by other uses in the front. And hopefully you'll see that play itself out throughout the standards that we're recommending. So if we dive into the proposed ordinance itself, there are 5 key elements to this new ordinance. First and foremost is a new format based on our research and best practice of jurisdictions that have undergone a rewrite effort of their code. The code is less text and more graphic in nature, has more depictions, and so therefore providing more user-friendly, a more user-friendly format. We're also providing for the applicability of, as I mentioned before, standards that accommodate the different context and the uniqueness of Pasco County. So we have identified 3 major corridors: the scenic corridor, the redevelopment corridor, and the transit corridor. And then all those other developments outside of those would just fall within a general standard. And then lastly, the freestanding recreational vehicle boat storage. We've identified it as a principal permitted use and gave it its own definition, as well as when it is an accessory use to the self-storage facilities. So these are some snippets of some formatting of best practice in new codes that you'll see around the country. You'll see there's more graphic, it's more tabular, and they're become more quickly referenced when a user comes to look at what's allowed and what's not allowed for a certain use. We've mimicked that for this ordinance. In terms of the applicability for how to define the geographic applicability of the corridor standard, we looked at 2 things. We looked at the current C1 and C2 location of those parcels in Pasco County, and you'll see the red squares and shapes all pretty much fall within the major corridors within the county. It's very few that fall outside of a major corridor. We also looked at the rural areas to help us better define where the parameter of a scenic corridor would be. And this is what we've come up with. The scenic corridor is limited to this green line, and the exact boundaries are identified below the map. It is consistent with the boundaries of the digital billboard ordinance that we currently have. In orange is the redevelopment corridors. Those are primarily already identified in our comprehensive plan. And then lastly, we have the transit corridor, which is the 54, 56 also identified in the comprehensive plan.
Excuse me, just 1 second.
So can I ask you a question back on that slide?
Go back? Mm-hmm.
Yeah, go back one. So the 41 north of 52,
Yes.
does that correlate to the ULI and the market studies and the areas that have been designated for these particular areas of the county? Because it seems to me like that particular area that, because it's 41, as the county matures, the area is just going to continue to migrate north. And it seems to me like 41 ought to be consistent.
All the way north
Yeah.
and south are saying. We can take that into consideration. Right now, the digital billboard ordinance has that as a scenic corridor. And then also it is, whoops, hold on. Currently it runs right along the edge of one of our rural area 2. So in
But
it.
that's a transition area, right?
That's the transition area, yeah. Although right now it is still very rural, but certainly can transition to something else in the future. And, you know, our codes, Mrs. Hernandez always comes and we have amendments, and as we grow and develop, this code will be no different than in taking that growth into account.
Can I ask a question? On that same topic.
Yes.
As far as roads, is there a reason I-75 and the Suncoast aren't labeled as anything?
Yes, thank you. State designated, the Suncoast is our scenic corridor. We don't have any C2, C1, and they're not frontages. So our standards right now just deal with the frontage setback. So they're not shown as a scenic corridor
They
with
weren't designated
standards.
because you don't have any C1 or C2 along them?
We do not.
Well, I guess the question would be, what if somebody rezoned to C1 or C2?
And they wouldn't have a frontage on it. Our LDC buffering then takes into account that scenic corridor from that perspective, that buffer. I'm sorry. And the general, but not the corridor standard. Yeah.
Alexandra, just to clarify, and maybe this answers the question, but these specific standards for the different corridors only apply to properties that have direct frontage on those corridors.
Mm-hmm.
If there's a parcel between you and,
Okay, I
if you don't have a frontage
okay,
on
because they're
that.
limited access roadways then? Is that why?
Yeah, because you can't drive on and off of them.
Yeah, you don't, the front of your building isn't to that corridor.
Okay.
You don't drive off, the drive aisles or drive cuts.
Okay.
Yes, limited.
Okay, that answers my question.
For the scenic corridor, let's see here. What we're trying to preserve is that view shed as identified in the comprehensive plan. And we've identified a 75-foot setback as from the right-of-way line from the corridor as a setback that would achieve that purpose. You'll see the modifications and changes since your packet was produced, that the lot size, we have it to just the 3 minimum acres and not have a maximum. You'll see that there was a clarification done on the building, on the buffer component, and it's really the building parameter landscaping. The height was increased to 2-story maximum, and then multi-use would obviously be permitted but should not exceed the 2-story. In the redevelopment corridor, the purpose here is we're really trying to activate the adaptive reuse as much as possible. And if you come in with a self-storage facility into an existing vacant building, lot size did not apply to you, and you would just meet any landscape requirement that is already provided for in our code and by the zoning district.
Can I ask a question there? What do you, the terminology here, reorganized parking, what does that mean?
Sure. So in an adaptive reuse condition, if you were imagine that this is a big box that self-storage has come in, there's a lot of surface parking in the front. And we'd like to encourage them to reorganize it to allow for their accessory use to be done, and then still allow for an out parcel or a liner building to come in front, and not just leave it as a surface parking lot. So we'd like to see that happen. We're not requiring it. It's just something that you're planting the seed to have them realize that you can take a lot more use out of the surface parking lot that exists, because parking overall for self-storage is minimal. So, and we've adjusted for that.
And also on that standard, you have horizontal multi-use. And I go back further in the document, it's item E, where it says multi-use. So is that the reference to that?
Yes.
So one or more compatible professional, commercial, or retail uses must be proposed to occupy no less than 15% of the ground floor of the principal building and have main entrances on the principal street as evidenced by the construction plan or building permit. So what are we saying there? That they have to have something other than just storage?
If they choose to, that would be the standard, that you would have a compatible use and it would take up at least 15% of your ground floor. If you're on the transit corridor and you do 50% of your ground floor as another use, then you can reduce that 250-foot setback and bring yourself right up to the corridor. Because then you're activating the pedestrian space and you're providing for the employment generating uses that we want to see along the corridor.
So professional, commercial, or retail uses. So just anything that fits into those categories. I mean, could that be a Starbucks?
It could be, yes. Could be a UPS store. It could be another office, not associated with, the little office with self-storage.
But so the only way that they get to do that, or the incentive to do that, to incorporate that, is it allows them to build closer.
Mm-hmm.
Okay.
Yeah. Because in the urban service area, which the redevelopment corridors and the transit corridors live in, you don't have a height restriction.
Right, okay.
So for the transit corridors, we've touched upon a little bit already on some of the standards. The lot size we made a clarification that it is 5 acres max for the self-storage use itself. So in this case, this parcel where the pink building is can't be larger than 5 acres. These two examples specifically are from Pasco County, the ones that Commissioner Moore had pointed us to, and they provide the situation where you have liner conditions, not exactly like this, but the building is set back actually further from the road. The self-storage is about 400 feet from the corridor, and it allows all the other uses to go around it. There's a hotel, there's a Wawa, there's a bank, and that activates the corridor in a fashion that's more compatible with high employment generating uses than the self-storage.
So when you say a liner building, you're referring to those examples that you gave, hotel, Wawa.
Hotel specifically, it could be it could be other uses. Right now in Pasco County, a Wawa is an example of that liner
It
We'd
could
like
be
to,
a strip retail building too.
you could have retail in the front.
I mean, I certainly agree those are jobs, but I wouldn't necessarily say they're good jobs.
Correct. They're more than just the one, one job, but they could be offices, medical office. There's no reason why a building like that can't hold those types of uses.
Stockbroker offices.
Those are good ones.
We have,
Jobs.
I'm sorry. We have then the general design standards that basically speak to the building themselves, taking from our 1102 section, specifically just the architectural piece, and those that section is noted in the standards. These buildings are rather large. So on average, we've seen in Pasco County over 90,000 square feet. And so our 1102 section speaks to buildings that are 25,000 square feet and greater. And we wanted to make sure that we captured this type of use with that kind of review. New, as we've spoken about, the multi-use standards and the incentive of the setback reduction. New to the ordinance is the reduction of the parking requirement. It used to be one for every 300 square foot of office plus one for every 1,000 square foot of the actual use. So you can imagine that everyone came in for alternative standards, and based on the input from the stakeholders, that 5 space requirement was sufficient. We've also defined accessory uses better and went along certain corridors that they have to be behind primary structures. So you don't see the propane and the truck rentals right up in front of your corridor. They're tucked behind that main building. And then again, we've also introduced the freestanding recreational boat storage as a principal permitted use. And here's more in depth on that piece itself. The definition that we're proposing is open, covered, semi-enclosed, or fully enclosed storage of recreational vehicles, travel trailers, other vehicles, and unstacked dry storage of pleasure boats of the type customarily maintained by persons for their personal use. Based on the industry, the national industry, there are 4 types of recreational vehicle boat storage: open, covered, semi-enclosed, and fully enclosed. So we've captured that in our new standards. We've kept the visual screening requirement as previously under the mini warehouse across the county. And then if those parcels are along those identified corridors, they would fall into also meeting the setback requirement. It maintains the special exception use in C1. It adds this as a principal permitted use in C2. And then the one other new part is that in the transit corridor, we're recommending that we prohibit just the open yard storage and kind of just the shed-covered boat and RV storage. If it's semi-enclosed or fully enclosed, that's fine, because it's seen more as a building and it can be set back from the transit corridor, much like the mini warehouse self-storage facility. But if it's just an open yard, that we would recommend it be prohibited from the transit corridor. The mobility fees, I'll defer a little bit to Mr. Goldstein, but the Board of County Commissioners, when they were reviewing the update, had placed a hold on specifically the mini warehouse one. The fees have been tabulated by the consultant, Bill Oliver, and this is what we're showing here. So we've not done any of the calculations. That was done during the time of the update, and it just was placed on hold until standards and review by the PDD staff came together with that for them to be able to vote one way or another of increasing the fee or not. What we have done as a placeholder is added the freestanding recreational vehicle boat storage Right now, we're using, just as a placeholder, what the current mini warehouse fee is. There is a manual that staff then takes and runs calculation and deducts it. And Mr. Girardi, you're probably better equipped to even speak to that than I am. Deducts it for, you know, it's not a building, it's just a storage of certain vehicles, and they tabulate what the mobility fee is. But there is a study going on right now that should be completed, I'd say, in 2 weeks or so, which then we can plug in those numbers from that study. But right now, it's a placeholder, and we wanted to let you know that that would be added to the mobility fee table. And with that.
But on that, I mean, these fees are, what you're showing here are the same.
For the freestanding, they are.
For the freestanding.
So go back to the other.
So for the other, you'll see that there's a zero incentive in all of the standard mobility fee schedules, and then there's a percentage reduced based on the incentive zone that you're in. So if you're in the mudroom or T&D or TOD, the incentive is reduced by a certain percentage. It was 33, and this proposed is 17% if you're in an urban mudroom. But all across the board, if you're just in the standard urban, suburban, or rural, your incentive goes down to zero.
So the fees that you should probably focus the most on these are the urban standard, suburban standard, and rural standard, because we don't get a lot of self-storage facilities in mudroom, T&D, or TOD areas. So they're just not, you just don't see them.
Mm-hmm.
So there's zero incentive.
Yeah, effectively what this is doing is saying that for a standard mini storage facility in the urban, suburban, rural area, it's removing any incentive that was in the old mobility fee.
Got it.
And to be clear, the Planning Commission actually took action on these fee increases when the mobility fee update came through and approved them. The Planning Commission rejected the fee increase on multifamily. I don't know if you remember this, but you approved the one for mini storage, did not approve the one for multifamily. When it went to the board was uncomfortable imposing the fee increase on mini storage unless it went along with the design standard changes. They wanted a complete package to consider. They didn't want to look at a fee increase in isolation without considering what the effect would be when you bring the design standards in too. So that's why that fee increase was delayed to this process.
Any other questions? I don't know if there's anyone here to.
So I do have a question.
Yeah.
In the ordinance on the table, page 4. So if I understand this correctly, I'm not saying I do, but where you have added the self-storage facilities and the freestanding, where you have the A and B, is that referring to these? Is that what that's referring to, or what?
I'm sorry, say, where are you again?
Those
I'm
are
sorry.
landscape buffer types.
Those are types of landscape buffers.
Type A, type B, type C, type D.
Okay, all right, so it has nothing to do with this, basically.
Well, they've revised these by adding the new categories on the bottom.
Oh,
He's on
you're in the
905.2.
whereas clauses?
He's on
Got it,
905.2.
hold on, yes.
I'm in the
I
ordinance,
was-
yeah.
Okay, I was looking at the news section itself.
Okay, no, I understand what Jamie said. So
Oh,
then
okay.
let me ask you this, then. In this ordinance, why did you eliminate right-of-ways?
We didn't eliminate it. What we did is correct what was incorrectly done in the table. We found that error, and so we went ahead and also made that correction. And Michael, you can speak to that a little bit more because you worked on it with current planning.
Yes.
We determined that there were some issues with the buffering table, the way that the table was structured prior. What the table was saying was that if, for example, a controlled access roadway were to come in, if FDOT built a new expressway through the area, then FDOT would be responsible
So if any one of those other uses comes up against a right-of-way, then column 14 applies, and that's type F. So it was just clarified and corrected.
So, can I ask you one question about the mobility fee thing? I get why you're separating out the, can you go to the next slide? I get why you're separating out the freestanding RV and boat storage. My question is, since that's usually, there is no square foot, I mean, should we be using a measurement other than square feet?
And yes, and that would hopefully come from the study that's being done. So that's one of those things that is, when someone comes and they get their mobility fee assessed, that there's, a hardship and a barrier because the unit of measurement isn't.
I'm just saying if that's a problem now, the unit of measurement, we probably shouldn't continue to.
And and whatever the study ends up suggesting that unit of measurement be is what we would.
David, I think the hope here, Alexander, correct me if I'm wrong, but I think the hope here is when this comes back to us in 2 weeks, that those are real numbers with real units assigned to them.
Okay, so we don't.
So it should be based on either spaces or acres or something else other than square feet, because you're correct, there is no building, so why do you have a building square footage?
Right, so it is very different than a mini storage, which actually has square feet. So presumably, we're going to change that once this study comes back.
Yes.
To whatever measurement was used in the study.
Correct.
We don't know that. Steve hasn't told us the measurement.
I don't know what he's using.
I don't have, yes.
Okay.
When I asked about the study, it was just like, it's still 2 weeks out. Well, it was 3 weeks when I asked, so now it's about 2
Well,
weeks.
I get why he wouldn't know the trips generation yet. It's a little weird to me that he didn't even know what unit of measurement he
I haven't asked the question.
I didn't ask specifically.
So one other thing, has this gone through the normal process that you would use for the stakeholders and all the opportunities for people to give input like you normally would in ordinance and all?
So the stakeholder group that will be meeting next week that we haven't due to scheduling conflict is the horizontal roundtable. But otherwise, we sent invitations and received feedback from the engineers who specifically do the self-storage in Pasco County and land use attorneys that specifically deal with these developments in 2 separate stakeholder meetings. We also did that survey that we got 103 respondents in terms of the visual broad citizens engagement piece.
But you're recommending continuance because you haven't met with the horizontal roundtable.
Correct, and we wanted to,
Right.
yes,
Okay.
and get
So I don't know
further
if that part
input.
answers your question.
Yeah, it does.
They haven't because that's one of the reasons they're returning.
But they're going to.
Yes,
Okay.
So this is going to horizontal roundtable next week?
on Wednesday, yes. We are on the agenda.
And then, so one other thing, so the facilities that are out there now, so are we just taking the position that they're built and that there's nothing we can do, or is there some thought about enhanced landscaping for those facilities that we could impose and give them so many years or whatever to come into compliance?
Our code right now speaks to if they were to add, if they did an addition, expansion, there's a table that does a calculation based on how much that renovation expansion is, then it triggers them to come into compliance with new code provisions. So I think that's how it would be addressed.
Address the existing if we wanted to.
Well,
correct?
yes and no. I mean, you have to understand this is the land development code. So typically, that only applies when somebody's initiating new development. They're building a new building, they're expanding an existing building. So this code regulates new development.
Okay.
If it's existing development and they're not changing anything, our land development code really doesn't apply. I mean, it's
So then I guess let me ask a question another way. Is there something that could be done?
I mean, the only thing that's close is like sometimes with signs, you can do what's called like an amortization where somebody has a non-conforming sign, that after a period of years, they have to make it conforming. We've never done that, with the possible exception of signs. I don't know that we've done that in any other arena, because there's a, first of all, there's an enforcement issue, because we have to be citing people, existing businesses, because they didn't do it. And there's a cost issue. Now, we do have a program where some businesses can apply to get landscaping funds to upgrade their site. Is that right?
Yes.
That's been our tool to deal with the existing sites, where we have a fund, the Tree Landscape Fund, where they can apply to use part of that money to upgrade the landscaping on their site. But I don't think it's a good idea to start thinking of this in the non-new development arena.
Right, okay, all right.
It's not really a land development regulation, if it's
No,
applied to something that's
I
not,
understand what you're saying.
it's already there.
Yeah, and to clarify, this code is looking at things moving forward. But there is a provision within, this is Nectario's Pito's planning and development. There's a provision in the proposed code that does handle the expansion or addition on existing facilities. But it's not going to mandate any changes to existing facilities.
But we do find that many uses over time tend to expand, or they go out of business and then they demolish. And if they demolish and build a new use, then they are subject to these regulations.
Correct.
So there's very few uses that are just permanently there and never change.
Yeah, I think what led me to ask that question is, obviously the BCC felt strongly enough about this to put a moratorium on doing anything so that we could continue, so that going forward, they're more aesthetically pleasing and which I agree with. But, there was a lot of buildings that are going on now and older ones that obviously got their attention. So,
Well, we have the same problem
they
with
could go
signs.
back and
We have the
and
same
do
problem with
something
signs. We have non-conforming signs all over the county.
Sure.
And unless they're making some material change to the sign, we don't make them take them down. But when they do, a new business moves in or whatever, we then say, hey, you have to conform with our code now.
Right.
So over time, we get the compliance that we want, but it's gonna take time. I mean, it is somewhat onerous on an existing business to say, what you did has to all go away.
Yeah, I get it.
We approved it that way, but now it has to all go away. I mean, it's got some problems with it.
Thank you.
Okay, Terry?
Yeah, I guess again, just to ask the question, is all of this stuff going to, I know you invited stakeholders to stakeholder meetings, land use attorneys, is this going to them before the roundtable meeting, or are they gonna just see this at the roundtable meeting?
Well, they've seen it now, once it gets posted. They saw the minor edits, I can pass that out.
I mean, is it possible to email to those people what the change, because I mean, the chances people see that people that go to the developer roundtable meeting or even reviewing this agenda is probably slim.
We can circle back.
Because there's, I mean, you guys know from the last time we sat together yesterday, there's a lot of stuff here.
Yeah, when we meet with the various stakeholders and circle back, we will have the most updated information for them to look at it. And then that information, once we get that input, come back again on the 24th and show it to the planning commission.
Okay.
So, Mr. Chair, even though staff recommended continuance, it wasn't noticed as a continuance, so you do need to take public comment.
So is there anyone here that would like to make a comment on this new ordinance, proposed ordinance? Just think like of interest.
Or they didn't want to sit through the plenary discussion.
So you need a motion to continue?
Yeah.
So I'll move to continue 2 weeks in Newport Richey?
Yes,
That
October
correct?
24th.
I'll second.
Okay, we have a motion to continue to October 24th and a second. There's no further discussion. All in favor?
Aye.
Aye.
Opposed? Motion carries. And I voted aye.
Thank you.
Move to adjourn.
Second.
All in favor?
Aye.
Nay.
Look at you two.